Well, I want to first start off by thanking my trial team of Steve Knippen and Julie Kraft. I'm just extraordinarily proud of the job that they did in what we have known for 2 years was going to be an extraordinarily difficult case, but one that we were strongly convinced needed to be brought. I gave a press conference at this very podium 2 years ago, and at that point in time was asked a question about medical cause of death. And we knew at that point in time, because of the conditions of the remains of this baby girl, that we would likely and ultimately were unable to prove the medical cause of death. And while we haven't had an opportunity as of yet to talk to the jury, I think that unfortunately that probably played a major factor in the outcome that we saw today. And as a result, I understand why the jury likely reached the result that it did. We certainly knew that this was a possibility, but it doesn't mean that you know, it's a day that, you know, we wanted to see this particular outcome. So, but I do think the jury had a difficult task, and I respect the work that they did in this case. There are a lot of very strong opinions on both sides of this case, and I think the fact that all of you are here covering this, you've seen it with respect to your web pages, with respect to your Facebook accounts, with respect to your Twitter feeds. There's a lot of strong opinions on both sides of this particular case, and this jury had to essentially put all of that aside and make a determination as to whether we were able to prove the case, and specifically the 2 homicide charges, by proof beyond a reasonable doubt. And while, again, we haven't had the opportunity to speak to the jury, my thought is that in all likelihood there are members on that jury who believe that Brooke Richardson killed her child. But I also think that there were people on that jury who believed that, notwithstanding that fact, that we didn't have the evidence to prove it beyond a reasonable doubt because we could not present medical cause of death. And the unfortunate thing, in my opinion, for that is Brooke Richardson created the situation that prevented us from being able to conduct an autopsy on that baby girl and to present to the jury medical cause of death, and deprived us of the opportunity to do that. And in a sense, as a prosecutor, in some ways it feels like that she's been rewarded in a sense for that. But nonetheless, I do understand why this is a difficult task for a jury, even for those people who are out there in the community who are absolutely convinced, as am I, that she caused the death of this child. I also understand why the jury came back with the verdict they did, and I think, not having spoken to the jury as of yet, I think it's probably largely attributable to that particular issue. So that's the statement I have at this point in time. I'm happy to open up to any questions that we have. Hold on, Anjanette first. No, if you believe that, and I think if you look at the closing argument today, in terms of that last few minutes before the birth, the fact that she was motivated, as her physician said, to keep that quiet till the end. If you believe that her intent at that point in time was to keep this quiet because she never wanted that baby to live, then the charge is purposeful killing, and that's murder, but by virtue of the fact that this is an infant, the charge is aggravated murder. So if you believe that she purposely caused the death of her child, as I do, then the charge is murder. We understood that there may be difficulty in a jury looking at this entire situation. I mean, it's a shocking set of circumstances, and that's why all of you are here, and that's why it's garnered immense and tremendous media coverage. It's a shocking set of circumstances, and people don't think that somebody like that would be capable of doing something like this. And we understood that when we presented the case to the grand jury, which is the very reason why we backed up the aggravated murder charge with the involuntary manslaughter charge. In the event there were jurors who could not bring themselves to believe, if you will, that she was capable of causing the death of the child, the fact that she has this baby and, if you believe her account, it's in distress, not getting any type of medical treatment for the child at that point in time, if you believe that that is what happened here, then that's an involuntary manslaughter charge. So, in my opinion, no, it wasn't overcharged. I think it was properly charged, and I think if you watch the closing arguments today, you understood why we felt like that was an appropriate charge for the jury to consider.
Mr. Fornshell, you stated publicly at that same press conference, you stated publicly that you had evidence to a degree of medical certainty that the bones were charged. We now know from this trial that you didn't and you don't. Would you like to use this opportunity to apologize to Skylar Richardson and her family?
No, I'm not going to apologize because I didn't do anything wrong.
You stated evidence that you didn't have.
That's not true, ma'am. 2 years ago,
You
ma'am.
never went public. You could have gone public. When you found out that that report was incorrect, after you had stated that you had evidence to a degree of medical certainty, why didn't you tell the public, I'm sorry, we were wrong?
We were under a gag order, ma'am.
And when the gag order was lifted?
The gag order is still on appeal, ma'am. If you'll notice, neither the state of Ohio nor the Richters, since the issuance of the gag order, have made any public statements in relation to anything in this case. Everything has been done through the filings. I reject the idea that somehow we did anything improper. As a matter of fact, ma'am,
publicly about evidence, isn't that a possible violation of the Code of Professional Ethics?
No, it's not.
I think you should check.
I'm well aware of the Code of Professional Ethics, ma'am. With respect to this particular case, what we did when we obtained that information, when we received that information, it was done by Dr. Murray, who was not somebody that was employed by our office. It was somebody that was employed by, I think, Mount St. Joseph University. They were retained by the Montgomery County Coroner's Office. The information that was relayed to us was that the bones had been charred, and that was what that statement was based on that particular date. Ma'am, stop. Stop.
You did make it public.
Ma'am,
You did not.
ma'am, let me answer the question. We obtained that information, and in response to that, because I lacked confidence, because I had an expert witness who initially gave the state of Ohio an opinion that the bones had been charred, and subsequently recanted that testimony, the first thing that we did was we reviewed our docket to find out whether this expert had ever given any opinions in any other cases, and number two, we notified defense counsel, and we advised defense counsel 2 years ago that we were going to get an independent analysis of this, of the remains of this baby. And so the idea somehow that we committed some type of ethical violation when we relied on evidence that was presented to us at the time, and when we got information that was inconsistent with that, we not only checked to make sure that it didn't affect any of our other cases, we notified defense counsel promptly within a week or so of getting this information, and we retained another expert to get with.
Do you have any physical evidence at all, any physical evidence, any independent evidence other than Skylar's word after saying 17 times she didn't? Do you have any physical evidence that says that she burned the body?
No, and that was testified to during the trial. We actually presented a witness. No, ma'am.
You went ahead with that charge.
With what charge?
I mean, with aggravated murder.
The burning of the remains has nothing to do with aggravated murder. That only has to do with actually the offense with which she was convicted.
What's the prosecution going to be doing for sentencing?
You know what? We haven't even had an opportunity to talk about that. That comes about tomorrow morning. And so we've been preparing for this press conference since we got the verdict an hour ago.
Was that the press conference? That they will speak with your office or anyone else?
They have not. Typically what we'll do, particularly in a longer case, what we will do is we will reach out to them. We'll give them a few days to kind of decompress because, frankly, they're this issue at this particular point in time.
Referenced earlier, or if it was the state, at least the day she was arraigned. said, as you had mentioned, look, we don't have a medical cause of death for this child.
Right.
But we have evidence this child, this little girl, was born alive, and that's why we charged her with the first, the reckless homicide, and the murder, because you have to have a life to be able to take one. Is that evidence? Was it Schuyler's statement that came under such scrutiny in this trial? Was that the evidence you all were referring to at the time, that this is the evidence we have that that child was born alive?
That was part of the evidence. That was absolutely part of the evidence. From our perspective, it was the attendant circumstances of everything. Everything that we presented in the trial, everything that was discussed today during the closing arguments that we used to try to convince the jury that this child was born alive. And again, I think that when you look at her actions are completely irrational for someone to take if that child she was intending to keep that child. Now, whether we were able to prove that beyond a reasonable doubt, that's a different issue. But I guarantee you there are members of that jury, I would surmise, and I know there's members of the community who are monitoring this case closely, that believe we were able to do that we were able to present our proofs and demonstrate that she committed this act. But again, this was a difficult task for the jury. I get it. They did not have a medical cause of death. It was attributable to Schuyler that they did not, and certainly that was something that we wanted to make sure that the jury understood, that it wasn't anything that the state had done to deprive the jury of that information. Nothing at all. We simply didn't have it because she buried the baby in the backyard and didn't tell anybody about it for 2 months.
About the
There
burning,
should have been, I have a two-part question. Do you think that maybe there should have been like a filing with the court after the statements about the charring of the bones, that maybe a filing that, I mean, I know hindsight's 20/20, but a filing with the court that said, okay, this was wrong. I mean, obviously, because the genie's out of the bottle.
Right.
As far as this lack of charring.
Right.
Should there have been
Actually,
something
we just
like
filed
that?
a motion about it, and you said it's misleading at
I'm not
best.
finished with my question, sorry.
Correct.
Should there have been maybe a filing with the court explaining that, or some type of, where you come out and say, this was wrong, there was a mistake? And I guess my second question is, it seemed like that was the basis for the second police interview.
Yeah, and I disagree. Let me answer the second.
That's what it
Can I answer?
appeared.
I understand that. And that was, look, this was an effectively litigated case on both sides. I can tell you unequivocally that the issue with respect to the charring of the bones or not was not the sole basis for the second police interview. That entire week, and I can't remember the day, I think the Friday was the first date, it was a Friday, the first week was the first interview. The subsequent interview, during the time period between that first interview and the subsequent interview, I was in communication regularly with not just Warren County law enforcement, the Warren County Sheriff's Office, but also the Warren County Coroner's Office, because there were other concerns that we had with respect to the entire circumstances of what was going on. So we were in the process of investigating any number of things in relation to that particular, what we believed was potentially a homicide. The story didn't make much sense to begin with, and so there were suspicions even after the first interview as to what had actually happened. It wasn't as if the investigation was wrapped up, as defense counsel would have you to believe, and all of a sudden that this whole issue with respect to the charring of the bones was what reignited this investigation. Nothing could be further from the truth. That was an ongoing investigation that entire week, and so the idea, I give the Rickers credit, it was a good strategy in terms of a trial strategy, but in terms of it being factually accurate as to what our office was doing during that interim, it's completely inaccurate.
So do you think she tried to burn the baby?
I don't know whether she did or not, to be honest with you. We presented the evidence that she had, and part of the reason, this was a really interesting case because you had multiple interviews where she's giving conflicting statements. And you have the state of Ohio who have statements that help our case and other statements that conflicted with it that hurt our case. And you have the defense in the exact same boat. And so it was kind of a nice, just from a trial strategy standpoint, and somebody that enjoys watching trials, it was interesting for me, not being in the mix, not being the one trying the case, it was interesting for me to watch how both sides were trying to do different things with respect to the statements to help them. What we ultimately made a determination to do, and this was after, obviously, we got the information I can't remember the exact date, but it was the information from Dr. Murray as to the,
August 17th.
okay, August, thank you very much, August 17th. So that's 3 or 4 weeks after the case had been presented to the grand jury. That's after we had obviously had the press conference. So at that point in time, we're relying on Dr. Murray's findings. And once we figured out that obviously that was inaccurate or there was at least a question, we retained another expert. But in the meantime, the question that we had to ask ourselves was, look, when you look at these videos, you have her all over the board. She is all over the board with respect to her statements, okay? So when you get to trial, the jury's going to see her all over the board with respect to these statements. And what are they going to believe? Are they going to believe that she's being honest when she says that it was stillborn? Are they going to believe that she's being honest when she says it was moving or gurgling? What are they going to believe? And as a prosecutor, you're not sure what a jury is going to believe. And so you have to discount that and look at the rest of your case and say, okay, setting that aside, and I think that was evident in our closing arguments today, which is she makes all kinds of conflicting statements in these interviews. Setting that aside, look at everything else that she did. And do you believe that she committed this act? We went through with Dr. Bassman yesterday, and I thought this was particularly effective for those of you that were able to see the cross-examination in relation to the issue of neonaticide, okay? Neonaticide, as everybody now is researching it, understands, is the killing of an infant, typically by the mother, within the first 24 hours. There are like 15 criteria for neonaticide, and Brooke Richardson meets 15 out of the 15 criteria. When you're reading the studies on neonaticide, when you read those studies, you would literally think that somebody was just writing about this particular case. And so when we're looking at the case, what we did when we got that report and realized that there were issues with respect to the issue of burning, was she telling the truth? Was she not telling the truth? Who are you going to believe? We recognize there's issues there. We then analyzed the case at that point as to whether we felt like this was a good case, and we did, in terms of whether we believe that she caused the death of her child.
Okay, so you
Yes,
said,
ma'am.
In a
You're getting awful close.
Okay, so
You're in their camera zone.
Sorry. In a motion filed by the videos, they
Right.
did complain about the fact that you said burning and that affects everything, and that's why they want to change the venue. And when you responded, you said defendant's assertion is misleading at best.
Correct.
And I will use the defendant's own words against her.
Right.
But at that time, you knew that Dr. Murray was wrong, and you knew that Dr. Latham was wrong.
No, Dr. Latham was absolutely correct.
She said there is no burning, and furthermore, there's no trauma to the bones.
I agree with that. Dr. Latham was absolutely
But
correct.
in court, we had the prosecutors say that we can't say the outside the baby was born.
Correct. And that's correct. That's correct.
But there was nothing to indicate.
Well, you had Ms. Richardson's statements. You absolutely did. What you're talking about in terms of the motion, well, that's an argument that you can make. That's an argument for trial. What you're talking about is an argument for trial. I'm not going to get into, well, the defense argued this at trial, so you should have never done this. Every case I have, the defense argues something at trial. What you're specifically talking about, and what that quote, saying misleading at best, was it was a misrepresentation. The way that, and I apologize because I don't have that motion in front of me, but I do remember the quote that you're talking about. Right. And when I said it was misleading at best, it was the specific quote that they were attributing to Dr. Murray, which was not correct, and it was misleading at best. In my opinion, it was a misleading at best, if not outright incorrect, recitation of what Dr. Murray had said.
But you can
Yes, ma'am.
press conference off.
You've got a conviction, but it's not the convictions, plural, you probably wanted before or after this case.
Correct.
Emotionally, is it embarrassing? Is it frustrating? Does it just come with territory that you don't get 100% conviction rate? What is this like for you to not have this case have the outcome that your office formally charged more than 2 years ago?
You know, I think it's, you know, certainly you have disappointment. Anytime you work hard for something and you believe in something, and we do. I mean, I understand why the jury did what they did. I get it. But I do believe that she killed her child. As I sit here today, I believe it. I understand there are proof issues. I understand that we had all these other things that we were going to have to do in order to prove this. But nonetheless, we knew it was going to be difficult. One thing that you'll learn about our office is that just because something's difficult, just because there's a potential that we may not win a case, doesn't mean that we're not going to try. And the alternative in this particular case is the evidence that we had in relation to her actions before, during, and after the birth, the fact that she meets 15 out of the 15 criteria of neonaticide, to just walk away and say, you know what, we're just not going to try. That's not who we are. That's not what we feel like our obligation is. And I think that, you know, certainly this is a case that's engendered a lot of emotion in the community on both sides of it. But I think this was a case that absolutely deserved to be tried. That baby deserved for us to go in there and fight and present the evidence and have a jury make a determination. And I am absolutely 100% comfortable with our decision in that regard.
David, talking about the baby,
Yes,
there's
ma'am.
another family involved here.
Absolutely.
Johnson's family.
Absolutely.
Behind them when the verdict was read, they were extremely emotional. Have you had a chance to talk to them after the verdict or interact with them? Have you kind of shed some light on how they're feeling right now?
Yeah, and we have sentencing tomorrow, and I don't want to speak. I always try to avoid speaking for families because I want to make sure they have the opportunity to speak for themselves. But in terms of their reaction, I think there was an understanding, because this was something that we had talked about for 2 years. I think for them, there was an understanding of why the jury verdict came back the way it did. But there was a disappointment, and this is just, I'm trying to not put words in their mouth. This is my observation. I think there was a disappointment by them because they felt like, and I feel the same way, they felt like the sole reason that the jury came in the way that it did was because of the medical evidence, and she's the reason that we didn't have the medical evidence, and therefore, in a sense, she essentially was able to accomplish what she set out to accomplish, which was to bury the remnants of this baby and not face significant consequences, just the lesser abuse of a corpse.
Mr. Fornshell, a lot of us have heard from people in the community, some who believe that this lady young lady should have been convicted, but they are actually extremely concerned in regard to the police lying to the parents, saying, your daughter doesn't need a police officer. What would you say to the citizens in this community who are now really concerned that their family could have something like this happen and possibly be wrongfully accused because of it?
Well, I think your question is somewhat leading in terms of its conclusions.
I disagree. I'm asking you a straightforward question. What would you say to parents who are concerned about the police lying to the parents?
Well, I will tell you that there are a variety of techniques that law enforcement officers use with respect to interrogations.
And they lie to the parents in advance.
Well, I'm not going to comment with respect to that. What I will tell you is there are a number of investigative techniques that law enforcement officers use. And one of the things that we will do with respect to the case is, again, you're asking me an hour after the verdict. One of the things that we will do with respect to this case is we will do what we do typically in all cases, but you tend to do it more, and I may have said this earlier, but you tend to do it more in cases where the outcome isn't what you think. What you would hope for, I should say, which is when we win a case, we think we did everything right because we won. And if we are unsuccessful in a case, we tend to be more self-critical. And that's a good thing. I mean, that's human nature. Because you're wondering, is there anything I could have done better? Is there anything somebody else could have done better? Whether that's a law enforcement officer, whether it's a forensic anthropologist, whoever it is. And that's part of a kind of a debriefing that we'll do after this case is over. And I'm sure that everybody involved in a case like this, whenever you have intense media scrutiny on cases, I think it can actually be a good thing. In some ways, it's not, because some of the information that gets out there ends up not being as accurate as what it should be. But I think that in some ways it causes us to look very closely at really everything that was done with respect to a case. So what I would want to do is I would want to number one, talk to the jury, because I want to know what they felt. What was it in their mind? What were their concerns? And then what we do after that, as we do in any case, is we then go to whoever it is that the jury, maybe if it was one of my prosecutors and they said, I hated how so-and-so did this. Then we go back to that prosecutor, and if it's me in a case, I have to think about it myself. I didn't like how you did this, or I didn't like how you did this, or I didn't like how the police did this, or I didn't like how the anthropologist did this. That's something that we'll have to evaluate with those individuals or that agency and take that to heart. I mean, I think it's something that, certainly I'm sure that anybody that's paid attention to this case, including any of the law enforcement agencies, have heard the concerns that were articulated.
Well, you are the top law enforcement officer in this county.
Right.
And so to parents who are now concerned and are distrustful of the police because of what they've seen here, what is your message?
Well, my message is that the overwhelming majority of law enforcement officers that I have ever dealt with in this county or any other county are tremendous individuals who are committed to trying to determine what the truth is, wherever it leads. That's what I would tell those parents.
You talked about
As a point
Evan.
of clarification.
Yes, ma'am. Yes, sir.
What, did you guys have a theory as to how the baby died? Because a lot of people have asked that question.
Yeah, and I think the question, look, there are a lot of opinions. I would say even internally in our office, there's a lot of opinions as to that particular issue, okay? But as a prosecutor's office, we have to rely on what evidence we have. And so I have a lot of opinions about what happened between midnight, the night, and the early morning hours on that Saturday night, Sunday morning when this baby was born, and later that day. I got a lot of opinions on that. But what we have to rely on is facts. And so factually, again, because she buried this baby and because of the decomposition and that nobody was told for the next 2 months, it's impossible for me to tell you whether it was strangled, drowned, or suffocated. What I can tell you is when we look at the research into this topic, defense made a big issue of the fact that there was no obvious signs of trauma. The very interesting thing is when you look at neonaticide, because these are not typically women that you would think of as being violent women to begin with. No criminal history. There's nothing in their history that would lead you to believe that they could commit what others would deem to be a very violent act where they're assaulting a child, where they're bashing their head in or anything along those lines. The general idea in those cases is that it's typically smothered, suffocated, or, suffocated, strangled, or drowned. And I think that what we tried to present to the jury, we understood we were not going to be able to point to which of those three, and that admittedly probably hurt us. But we can't create evidence that we don't have. And so what we presented was these are common methods used by mothers in these circumstances, and these methods are logical in this particular case for somebody who was doing everything they could to try to keep that child from making noise and try to keep somebody from finding out.
So was there ever a point that you said, we've got to pull the plug on this?
On what?
On the case?
No.
You knew there was a struggle. Did you ever want to just pull it?
No. No, absolutely not. Because I think that when you looked at all the attendant circumstances here, this was a case that we strongly believed deserved to be heard by a jury, and to let a jury make a determination as to what level of culpability, if any, they felt that she had. We felt like we owed it to that little girl, because the other option is, again, we have these texts, we have what happened leading up to the death of this child, we have, admittedly, and I think objectively, anybody that hears that her story is that she's trying to give birth to this baby by not making a peep in the middle of the night, it's buried in the background, she's getting rid of the evidence, doesn't tell anybody, and again, meets 15 out of 15 criteria of the profile of a neonaticide killer, right? We felt like that was sufficient evidence to go forward to not just a grand jury, and the grand jury indicted it, but we also understand that even if the grand jury indicts it, we've got a higher burden of proof. And that burden of proof is proof beyond a reasonable doubt. And the jury didn't feel like we met that burden of proof. We respect that, we accept that, but we also don't think that it means that the case shouldn't have been brought. There are cases out there that, like I said earlier, you make mistakes in and you still win, and there's other cases that you try as close to perfectly as you possibly can, and you lose. And that's just the nature of trying cases. But in this case, I think that there was not a single person that was associated with the investigation of this case, to my knowledge. There was not a single person that was associated with the investigation of this case that felt like that this case should have been dismissed at any point along the way. We felt very strongly about what we believed happened. The question for us for 2 years has been, will we be able to prove it beyond a reasonable doubt? And we weren't going to not try just because there was a chance we would lose. I knew 2 years ago if we didn't win this case, I knew these facts 2 years ago. With the exception, when I gave that press conference, I knew everything with the exception of that Dr. Murray was going to, obviously recant her opinion 3 weeks after I give a press conference quoting her opinion. But with respect to, everything else, we knew 2 years ago how difficult of a case this would be. We knew 2 years ago, or I knew 2 years ago, that if we were unsuccessful, this is the kind of case that's going to get publicity. And if we were unsuccessful, I was going to get questioned very aggressively by the media, and there were going to be strong questions toward me. I knew that 2 years ago. I felt strongly that this little girl deserved to have these facts aired in an open court of law, and I'm very proud of my team for everything we've done in this case from an ethical standpoint. I think, and I don't think I'm speaking out of turn, Mr. Rickers and I exchanged text messages before the verdict had come back today. I congratulated them on a good trial, and his specific comment to me was, I thought your folks did great, and I appreciate how ethical you were in conducting this prosecution. That was a direct text message from our opposing counsel. I feel good about how we handled this case, and I think that for me, it was, again, something that it had to be tried.
It had to be the younger Charlie that sent you the text.
It was. Yeah, I don't think the older Charlie knows how to text.
I think we could use a moment of levity here, but I have two other questions.
Yes, ma'am.
I'll try not to do a two-part question because then I think it gets lost. First question, though, I'm going to go back to that part one question of my first question.
And I apologize if I just answered the part two.
I'm not a lawyer, so bear with me.
Right.
So should there have been like a filing with the court that we could have read, and I wasn't covering it back then, but a lot of people were, that said maybe the charring was a mistake so the public wouldn't be under that impression that the charring took place. I know you're saying
right.
She tried to cremate the baby, but then
Right.
they're saying that was coerced. And,
Right.
you know.
Well, and I think to answer your question, you also have to understand, I mean, the coercion is an argument that they make. And I'll like I said, we've not had the opportunity to speak to the jury as of yet, okay? But at that point in time, just let me finish my answer, okay? At that, I see you ready to jump again,
Yes,
all right?
always.
Give me a second to answer my question. Don't be like, no. At that particular point in time, so when we give the press conference initially, we have statements by the defendant, okay? And we have a report, I shouldn't say a report, we have an opinion, would be a better way of putting it, by a forensic anthropologist, okay? So what you're suggesting is, should there have been a filing subsequent to that saying the report or the opinion by the expert had been withdrawn, and now we're just relying on the statement of the defendant. And it's a fair question. I don't have an issue with the question. Here's the things that we as prosecutors have to navigate, though, and there's a lot of times that you ask me questions in terms of, well, what evidence do you have on this, and what evidence do you have on that, okay? We still have her statements, all right? We still have her statements. And so when you get into that kind of situation, now I have to say, okay, a expert withdrew their opinion. but I can't tell you that the statements still exist. And so we understood what the Rickers were going to do. We were all under a gag order. There were communications between us. We were actively communicating with respect to this particular issue. We tried to do our best to just make sure that we were doing stuff through the court. And that issue was litigated. I mean, the Rickers actively litigated that. So it wasn't as if that issue wasn't out there at an appropriate time. They absolutely put it out there, and we responded. I kind of dispute your characterization of we didn't put it out there. We responded to those motions in a way that we felt was factually accurate and factually depicted the situation as it existed at that point in time.
Abuse of a corpse must outrage community sensibility. That's
Right.
what the law says. How did this bearer or the alleged abuse of the corpse, as the jury convicted her, outrage community sensibilities?
Well, I would have to ask the jurors. I can tell you from my perspective, the reason we presented it was when you bury a baby in the backyard and simply don't tell anybody for a couple of months, and you've got animal activity where animals, we didn't even have all the bones. And whether that was as a result of animal activity or not, I think Dr. Updegrove, I can't remember if he testified as to this issue. I know I had conversations with respect to this issue. Was there a possibility that any of these missing bones were missing because as it decomposed, the smell attracted animals and animals essentially pulled it away? I think that outrages community sensibilities. And so that's, obviously the jury agreed. Again, I can't speak for the jury, but I think most people who look at what happened would agree. I don't even think the Rickers argued to. They said she put a flower pot on the grave, and that was kind of the argument that they made as to why this wasn't outrageous to community sensibilities. But I think that even they recognized in this particular case that of all the charges, that was the one that they weren't really.
Well, was there a flower pot there when you guys got there?
I think the testimony was that there was flower pots near that area. Yes.
The outcome of this, David,
Yes.
you mentioned how difficult this case was.
Yeah.
Given the outcome
Right.
for your office,
Sure.
does this lead to any hesitancy for the Warren County Prosecutor's Office to try similarly difficult cases moving forward?
No, I don't think it. Every case is unique as to its facts, and so I hesitate to make a generalization in terms of are we going to be gun shy to go out and try cases that we think are difficult cases. Every case is so unique that you have to look at a particular case at the facts in that case. But if you're asking me the question, are we going to? There's a lot of cases out there that I think that we've tried that other people. And maybe some other prosecutors' offices may not have taken a run at. And sometimes we're successful and sometimes we aren't. Certainly we have a standard of ethics that we have to apply to. We have to believe in our case. We're not going forward on a case where we think somebody's innocent, ever. But it does come down to this analysis of even if I think that this particular person did it, do I believe I have the evidence? And sometimes it's more than just do I believe I have the evidence. How do I think the jury's going to react to that evidence? And this is one of those cases, and I think it's been borne out in the comment section of all of your Twitter feeds and all of your Facebook feeds and all of those kinds of things, which is there are people that watch this case that absolutely believe that she killed this baby. Okay? There are people that watch this case who absolutely believe that she did not kill this baby. I think the biggest category of people out there, and this is just an assessment on my part, are people that listened to our case and said, you know what? I think she killed that baby, but I just don't think they can prove it beyond a reasonable doubt. And that's a fair criticism. And in those kind of cases, where it's that kind of case, where it's, I think it happened, but are we there as to the burden of proof? Yeah, I'll proceed on that case if I think it's a worthwhile case to pursue. And when you're talking about these facts and this situation and a baby being married in the backyard and nobody telling anybody about it for a couple of months, and but for the fact that she was confronted by the doctor, who knows if anybody would have discovered that baby? We don't know. In that kind of situation, that's the kind of case that we're going to go forward on.
You sent a subpoena to Kim Richardson. You did not call her. A
Yeah.
lot of people are speculating that might have been some kind number one, why did you issue a subpoena? Number two, why did you not call them?
The issue with respect to Kim Richardson was a foundational issue. So Skylar had deleted a bunch of stuff off of her text, if you recall, from the trial, off of her phone, text and other things off of her phone. There were certain things that were extracted from Kim Richardson's phone that were not on Skylar's phone. And so until we got to the point with Detective Long, where he is going through those text messages, we were not certain whether you have certain rules of evidence in terms of laying foundation to demonstrate this is actually Kim Richardson's phone, okay? There were certain foundational things that we were going to have to potentially go through. Ultimately, though, there was no objection by the Rickers. There was no issue on a foundation side from the court, and so we didn't end up needing her for a foundation standpoint. As to whether you could have gotten anything else out of her, it's kind of difficult. And there were several things in this case that were made difficult by virtue of the fact that I think there were people that were friendly, if you will, toward, or sympathetic might be a better word, toward the Richardson family. And you call them on direct examination. And on direct examination, we ran into this issue with Dr. Andrew. If you recall, there was this continued back and forth with Dr. Andrew of, wait a second, Dr. Andrew, when you talked to law enforcement, you specifically said, she said over and over and over and over again, I can't have this baby. You indicated, look, I don't normally give these type of warnings. I don't normally do it. I did a fundal height measurement with my hands. So that's our witness. And then 2 years later, you get them on the stand, and they start dodging and weaving on you. And as the person who's calling them on direct, you're limited as to what you can do to get that information out. So I raised that issue with Dr. Andrew to talk about with respect to Kim Richardson. You know, that's a difficult witness to control. There wasn't too much additional information that we knew we were going to be able to get out of Kim Richardson that we didn't think we were going to be able to get out of the text. You're not going to put a witness on the stand and start asking them questions on direct that you don't know the answer to, and you're certainly not going to do it on cross-examination. Anybody knows that's rule number one of trial advocacy. Don't ask a question you don't know the answer to. And so there were a lot of issues with respect to, you know, even early on in this case, what would we be able to get out of Kim Richardson that we knew for sure that we would have been able to get out of Kim Richardson? You don't go to trial and start on a fishing expedition and say, Kim Richardson, when did you actually find out that Skylar was pregnant? When did you actually find out when she delivered the baby? You don't do that at trial. And so all of those kind of went into play into that decision. But the reason that we kept her on the witness list wasn't an issue of strategy or trying to keep her out of the court. Heck, I think with those text messages, probably the Rickers didn't want her in court. As a matter of fact, you know, you didn't see them. Once we had rested our case in chief, she was no longer going to be a witness. If they would have asked us if they could bring her in the court, we wouldn't have had an issue with it. But I'm not sure after those text messages they wanted her in there.
Was the grand jury aware of Dr. Murray's opinion before the grand jury reached its indictment?
Ma'am, the grand jury proceedings by Ohio law are strictly confidential, and I'm not allowed to.
If you didn't give that to them, that would not violate the law. Was that opinion given to the grand jury? You could say if it wasn't.
No, I'm not going to tell you anything that was presented to the grand jury. Under Ohio law, I am not allowed to talk to you about matters before the grand jury at all, ever, absent some approval by the court.
You talked about Skylar being a good girl when we talked about
Right.
that motive.
Yeah.
Do you think it helped her in court, that good girl image?
So this is another one of these things, and I talked earlier. This is another one of these things that was really interesting, just from a trial advocacy standpoint. In terms of, I said I felt like at times in this we were arguing different sides of the same coin. So, you know, they end up calling a bunch of character witnesses, right? And you know, people might have questioned, why didn't you, you know, she's a good girl, she's perfect, she, you know, helps autistic kids. And I don't have any reason to dispute any of those things, right? We don't have any evidence to dispute any of the things that they testified that she did. But the flip side of that coin is that she also was very concerned about her image. And I think that was borne out in the text. And so from our perspective, what they were doing by presenting these witnesses also went to our motive all along. If you go back and look at the press conference 2 years ago that I gave, I said, yeah, she had this very good, clean-cut, all-American girl image. And we wanted, and for whatever reason, unfortunately, I think she thought that this pregnancy would destroy that image. And Dr. Bassman came in and talked about the rejection, and they tried to do that. They tried to tie that into the issue of the coerced confession. And we looked at it from the standpoint of, no, that actually plays into exactly what we're saying with respect to the issue of the of why she would do it to begin with, because she didn't want it rejected by her mom, and she certainly didn't want to lose her boyfriend Brandon. And so I think, you know, the whole good girl thing, I don't know how the jury perceived that, but both sides were able to argue. That was one of the other things in this case, that both sides were really able to argue.
So this is a compound question, obviously.
No compound questions. Objection sustained.
How much was this an expensive case for the prosecution to put on with tax dollars? How much did you spend on expert testimony, flying people in, hour-by-hour day rates? Talk about.
I don't think we flew. I'm trying to think if we flew. Did we fly anybody in? I don't think we flew anybody in. No. No. Not even close. Not even close. No. I mean, from an expert standpoint, not even close. Any capital case is way more expensive than this. Any capital, any death penalty case that you have is extraordinarily more expensive to the taxpayers than a case like this. In terms of, you know, she had private counsel, so you didn't have public defenders being paid to represent her, so you didn't have that expense. You know, I don't know what our overall expert fees are going to be. We had Dr. Latham. I'm trying to think if there was any other expert. We had Dr. Brady. And so I would say, in terms of out-of-pocket, actual out-of-pocket expenses, we might be at $5,000 to $10,000 in this case, maybe. I don't know. I haven't actually sat down and written that out. In terms of man hours, though, we don't, as a prosecutor's office, it's not like when we're in the private sector, we write down our billable hours to the 6-minute increments. We have an experienced group of lawyers here who are available to try cases like this anytime we might get a case like this. And so that is kind of a sunk cost, to use a business term, with respect to this. So in terms of out-of-pocket cost, it wasn't by any means close to being one of our more expensive cases. Wait, I'm going to let him. He hasn't asked a question yet.
Two things. So in dealing with prosecutors, we always hear you charge what you can prove. Once you lost the evidence, I guess, did you ever think about just going forward with only the involuntary manslaughter charge?
Yeah.
And do you think if you had only presented an involuntary manslaughter case, would that have increased your odds of getting that charge? Or do you think that once the jury decided that aggravated murder wasn't it, that also took off the involuntary manslaughter charge?
No, I think it was interesting. I think the issue of the live birth, it did relate to both, and we understood that. And I thought they did an effective job in closing of making sure that the jury understood that. And so, depending on how you looked at that, if you believe that it was a live birth, then you could have either of those two. You could look at that evidence and say, I think she killed the baby, or I don't think she killed the baby. I also don't think she helped it when it came out and she saw that it was in distress. And so I think both of them were appropriate charges to present. I think both of them were supported by the evidence. And as far as did we ever reevaluate, the issue of the burning only related to the last count. And ironically, that particular evidence only related to the last count of the indictment, which was the only account that she was convicted of.
When will the remains be returned back to the Richardson family?
Well, you're assuming that they're going to be returned to the Richardson family. There's two families involved here, and one of them was convicted for abuse of a corpse. So there's a father involved here, so I don't know the answer to that question, but I will tell you that there's two families here, and one of them was not convicted of abuse of a corpse today.
Do you expect the paternal family to give some sort of victim impact statement tomorrow?
I would think so.
About witnesses that weren't called, a lot of us are hearing from people in the public and have observed ourselves when you have a lead detective who doesn't testify, and
by the way, that's not even close to the first time that's happened.
I'm just saying, can you help us understand, help the public understand, in light of the controversy about the interrogation, why was Detective Carter not called?
Detective Fain had more stuff to testify about because he had gone back on the search warrants. And so you have Detective Carter and Detective Fain both depicted on the video. So if you were just talking about the video, you could have flipped a coin and said, we want Detective Carter or we want Detective Fain. Because Detective Fain did more than Detective Carter, then we made the decision that we were going to call Detective Fain as opposed. There's nothing nefarious in terms of our decision to call Detective Fain over Detective Carter. It had to do with the fact that Detective Fain had the same information in terms of the interrogation. As a matter of fact, he had more because he was involved in the first interview. She was not. He was involved in the second interview. She was. He was involved more extensively in the search interview or in the search warrant execution than she was. So that was the reason.
When will we get everything from the case?
Well, everything from the case. Not today. How's that? I assume, look, we've got a bunch of pending public records requests, so that's going to take some time to work through, but we will certainly be as diligent as we can to get the information out that has to be, obviously, there's certain things that have to be redacted and whatnot. But we'll have to go through that, and what we'll effectively have to do is go through all the information and kind of create a master public records file, and then we'll just ask you all to please give us thumb drives so we can dump it all on a thumb drive for you. That's probably that's going to be the easiest way to do it because you're going to want video, I'm sure.
What thought would you like to leave the public with about the context and where this leaves us?
Yeah, I think that, again, I believe in the criminal justice system, and I believe in it when we're successful in cases, and I believe in it when the outcome is not necessarily what we want. And in this particular case, the jury had a difficult task. I understand that. Personally, am I disappointed? Yes, I'm disappointed. I'm disappointed because my staff, I thought, if you saw this trial, I think you saw some excellent lawyering going on, and so I'm disappointed for them, not most. I'm disappointed for that baby the most. But it's one of those things where you have to make a decision in this position what you believe the right thing is to do, given the circumstances that you have. And I stand up before everybody today completely comfortable with ethically where we ended up on this case. I believe in the case. I also understand why the jury made the decision that they did, and I think that there's learning opportunity for everybody involved in this case, and that's something that's not unique to this case. We'll do that over the next few weeks and months and figure out, is there anything in relation to this case that we could have done better, and then we commit ourselves to the next time that we go out. We've got big cases. We have the Hopkins case with a teacher that's accused of inappropriately touching a whole bunch of first graders. We got a lot of other big cases. We got 2 death penalty cases that are pending. This may be the most salacious case that was currently on the docket of the Warren County Prosecutor's Office. That doesn't make it the most important case. We've got a lot of important cases out there that we're doing a lot of good work on, and we're going to continue to do that. And I think that we've got a history, at least, and I think it predates me, but certainly in the 8.5 years that I've been in office, I think our Warren County community has been able to see that I'm able to make decisions that are difficult as far as moving forward on difficult cases, and knowing in those circumstances that I'm going to take criticism. I'm willing to take positions in cases. I'm thinking about a case that you talked about where we had a lady that left a baby in a car who ended up dying. We made the decision in that particular case that there was no law that was violated, and we took a lot of flack for that. And that's just the nature of the job that I hold. But it's still just a tremendous honor to be in this position, and it's not one that I take lightly, and it's not anyone that anybody in this office takes lightly. We understand our responsibility to our community, and I think that all of us come in today with that mission every day to work with that mission and that purpose.
You mentioned social media earlier.
Yeah.
A lot of people talking about this case. What I'm seeing a lot of is people wondering what we can expect tomorrow when it comes to sentencing and a punishment, because there are quite a few people who, some can't believe that
Right.
on all of those charges.
Sure.
Some, obviously wish that she would have been found guilty. What can we expect from tomorrow?
Anything from probation to 1 year in prison. And I have no idea where Judge Oda is going to come out on that.
What's your reaction to that kind of a sentence in general after this case?
Well, I mean, I have an opinion as to what I think happened, but based on what the jury decided, I mean, that is the appropriate punishment under Ohio law. That's the only thing the judge can take into consideration. The only thing the judge can take into consideration tomorrow at sentencing is what's her background, what's her history, what's her background, and is these other factors that go into the seriousness of the offense and things like that. But he's limited by what she was convicted of, and so we'll go in there tomorrow, and certainly it's her responsibility and her responsibility alone that all of us are in that situation, in this situation. This is on her. That's the reason that all of you are here. It's nobody else's fault but hers. And so I think that's going to be our message tomorrow with respect to this, is that the only person that can be blamed for this entire mess, if you will, is Skylar Richardson.
So House Bill 86 says at most she can get 180 days local jail time and community control such as probation.
She can get up to 1 year in prison.
1 year?
Yeah.
In local or?
Well, he could decide, look, she can go to prison for up to a year. The judge could do anything from probation to prison.
Are you going to be pushing for jail time or
Yes,
prison time?
certainly. Certainly.
The
Yeah,
maximum?
yeah, absolutely. Yes, because I don't think, again, I think had that doctor not confronted her, I don't think in a million years that Skylar Richardson ever wanted this to come out. I don't think that was part of her grand plan, was that she was just going to bury the baby in the ground for a temporary period of time, and then at some point in time in the future was going to come clean and accept the responsibility and consequences of her actions. I don't believe for a minute that she ever intended to do that. And so in that regard, that would be the argument I would be making to the court. Not I, but we will be making to the court. They didn't even know they were going to be making that argument. Now they do.
The house arrest be factored in the house arrest for all these 2 years?
No, that's an issue of bond. That's a function of bond, and so she shouldn't be given credit for curfew. There's been some case law back and forth on that particular issue, but I don't believe she'll be given any credit for curfew. Yes, sir.
Any charges could come against her parents and
Yeah. What I would tell you is we presented to the grand jury the evidence that we felt that we had, okay? And the charges that came out of the grand jury were the charges that you saw during the course of this trial. I don't anticipate that there would be, absent additional information coming to our office, that there would be additional charges in relation to this matter. Other questions? All right, well, I thank you very much for coming.
Thank you.
Thank you.